everyone, today we're exploring Section 106 of the National Historic Preservation Act, which ensures the impact of federal projects on historic places is properly considered. We'll break it down into plain terms and guide you on how to work with us at the Idaho SHPO if your project involves federal action.
So, what is Section 106? Section 106 is part of a federal law, the National Historic Preservation Act, or NHPA for short. The National Historic Preservation Act was created in 1966 to ensure that the federal government considered the impact of its actions on historic and cultural resources before moving forward with projects. At the time, large-scale federal programs such as urban renewal, highway construction, suburban development, and even dam building were rapidly transforming communities and landscapes across the country, often resulting in the demolition of historic buildings and archaeological sites without any review or public input. Section 106 was designed as a stop, look, and listen requirement. It does not mandate the preservation of every historic resource, but it does require federal agencies to identify historic properties, evaluate how projects may affect them, and consult with the State Historic Preservation Office, tribes, and the public to seek ways to avoid, minimize, or mitigate harm. In this way, Section 106 balances progress with the responsibility to protect the nation's heritage. Section 106 applies whenever there is a federal undertaking. An undertaking takes place when there is a project, activity, or program that is federally funded, licensed or permitted, located on federal lands, or is otherwise carried out by a federal agency. To trigger Section 106, that project must also have the potential to affect historic properties. Historic properties are those that are listed in or eligible for listing in the National Register of Historic Places, or NRHP. Properties might be buildings, structures, objects, sites and archaeological sites, districts, and linear resources like railroads. Properties typically considered eligible for the NRHP are those 50 years old or older that meet one or more of four criteria. Criteria A, association to important historical events. Criteria B, association to people important in history. Criteria C, good representations of design or technology. And Criteria D, those with information potential. EBR1, or Experimental Breeder Reactor Number 1 on the Idaho National Laboratory, was listed in 1976. At the time, it was listed under Criteria A and C for its connection to nuclear energy development in the United States, despite its recent construction. Because it was listed before it reached the typical 50-year guideline, this means it met something called Criteria Consideration G. In this case, EBR1 was so significant to history that it was already eligible for listing. EBR1 is also an example of a historic property that is significant at multiple levels. It is significant for the state of Idaho, but also nationally. It is important to keep in mind that historic properties may be significant at national, regional, state, and local levels. A property is only determined eligible when it exhibits both its significance to history and its integrity, or how well it communicates its significance based on its current appearance. If you're unsure, ask yourself, does it look mostly as it did when it was historically important? To sum up, if a project uses federal dollars, permits, or lands, and it has the potential to affect historic properties, Section 106 applies. Several groups play a role in the Section 106 process. Federal agencies are responsible for directing and moving through all parts of the compliance process. State and tribal historic preservation offices, SHPOs, and TIPOs advise and consult during all parts of the process. Not all tribes have a tribal historic preservation office or officer. In that case, the project proponent should engage in consultation with both the SHPO and the tribe for undertakings occurring on tribal lands or that may affect tribal interests. Local governments, organizations, and the public also have a right to be involved. These may be historic preservation commissions, historical societies and museums, or other interest groups. In some 106 consultations, the Advisory Council on Historic Preservation, or ACHP, may wish to be involved. They must be notified in the event of what we call an adverse effect, which we'll get to later. The Section 106 process, outlined in regulations in 36 CFR Part 800, has 4 basic steps. Step 1 is to initiate the process. The federal agency, in this example the Idaho National Laboratory, identifies the project and consults with the SHPO or TIPO, tribes, and other stakeholders. To initiate the process with the Idaho SHPO, the federal agency or consultant must create a Section 106 project in ICRIS, the Idaho Cultural Resources Information System. Step 2 is to identify historic properties. The agency, sometimes with consultants, documents the project area to determine if historic properties are present. Step 3 is to assess effects. If historic properties are present, the agency evaluates whether the project will affect them, and if so, how. There are 3 effect findings: an adverse effect, when at least one historic property will be negatively impacted; a no adverse effect, when historic properties will not be adversely impacted; and a no historic properties affected or no effect finding, when either the properties are not eligible for the NRHP, or when no historic properties present in the project area will be affected by the project. If the project results in a no adverse effect or no historic properties affected finding, the consultation process is complete. If there are adverse effects, the process continues. That brings us to step 4, resolve any adverse effects. Some undertakings that impact historic properties may result in a finding of no adverse effect if the SHPO and federal agency can agree during the review process to avoid or minimize minor impacts. If the project will harm historic properties, the agency works together with the SHPO, tribes, and all other parties to look for ways to avoid, minimize, or mitigate the damage. The goal isn't to stop a project. It's instead what we call a process law that guarantees preservation is considered in the federal decision-making process. If there is an adverse effect, this means that the resource with the implementation of the project will be negatively impacted. Adverse effects may include partial or total physical destruction, alteration that is not consistent with the Secretary of the Interior's standards for the treatment of historic properties, removal of a property from its historic location, a change in the property's use that may significantly change its character, the introduction of new visual or other atmospheric impacts, or neglect or transfer of the property outside of federal oversight. It is important that project proponents evaluate all possible impacts the project may have on historic and archaeological resources. These may include atmospheric effects, which include visual, auditory, and in some cases even olfactory or other effects. Any of these effects could adversely impact the integrity of setting and feeling of a resource, even if they don't physically alter the resource. Project proponents should also consider what we call cumulative effects. Cumulative effects are those that may result in an incremental loss of a historic property's character over time. When there is an adverse effect, the interested parties enter a discussion that may include modification of the project to avoid the effects. If avoidance is not possible, and minimization options have been discussed, and there will still be harm to a historic property, then the federal agency is required to implement mitigation. Mitigation measures seek to address the impacts to the historic property. Sometimes the parties may decide to use a mix of avoidance, minimization, and mitigation to resolve the adverse effect. These measures are formalized through a Memorandum of Agreement, or MOA, between the federal agency, the SHPO or TIPO, and other interested parties. The MOA is a legally binding document that outlines specific mitigation actions, which can vary widely depending on the nature of the resource and the complexity of the project. In the document, these actions are referred to as stipulations. In many cases, once the MOA is agreed upon and signed by all signatories, the project can move forward. However, certain stipulations may need to be carried out before the project can be implemented. For instance, an MOA for an undertaking with impacts to an archaeological site may stipulate that data recovery or additional investigation with ground-penetrating radar technology should take place. An MOA for an undertaking that impacts a historic building may stipulate that further documentation of the structure be completed before the project begins. There are many types of mitigation that may be appropriate. Some examples of mitigation might be bricks and mortar, or the physical preservation of a historic building, a documentation effort of other historic properties, data recovery for an archaeological site, National Register nominations or contact studies, or even public engagement projects like a PBS documentary. It is important to note that there is no set standard mitigation, although there are a few guiding principles. A resource's National Register area of significance does not dictate mitigation solutions, although they may be considered. Any mitigation solutions should be compensatory to the scale of the adverse effect and the significance of the resource. It's also meant to be a creative and collaborative process. Ideally, it should also provide a benefit to the public and be historic preservation related. Put simply, mitigation is whatever all parties agree to. Every federal project with the potential to affect historic resources should go through the Section 106 process. However, there are options for streamlining the review process. According to the NHPA, there are 5 program alternatives. They are programmatic agreements, exempted categories, standard treatments, program comments, and alternate procedures. The most common program alternative are programmatic agreements, or PAs. A PA is a document developed with coordination between a federal agency, a SHPO, tribes, other interested parties, and the SHPO. PAs allow federal agencies to streamline and tailor the Section 106 review process to their needs. There are 2 types of PAs. Project PAs may be developed for phased or complex projects. They may be necessary when an agency cannot fully identify historic properties or assess project effects before making a decision. These documents can be helpful when other regulatory reviews, such as NEPA, need to be completed before Section 106. A program PA can establish alternative methods for addressing the effects of phased or repetitive undertakings. As an example, the Idaho SHPO has a program PA with the Department of Energy for the Idaho National Laboratory site that streamlines and reduces the number of consultations with the SHPO. With the use of ICRIS, Section 106 review with the Idaho SHPO is clear and straightforward. Step-by-step project creation guides and ICRIS training videos can be found on our website.
If you're working on a project that's on federal land or uses federal funding or permits, you'll likely have to participate in the Section 106 process. That means sharing project details, working with your cultural resource or heritage professional staff, the SHPO or tribes, and sometimes adjusting plans to protect important places. The key takeaway is, don't skip consultation. It's required by law and it helps avoid delays down the road. To sum up, Section 106 is about making sure historic places are part of the conversation when federal projects are planned. It doesn't force agencies to preserve every resource, but it does require them to stop, look, and listen before moving forward. As you encounter projects, remember, early consultation and open communication make Section 106 much smoother. Think of it not just as a legal requirement, but as a way to balance progress with preserving the places that tell our story.